witness in the Senzo Meyiwa murder trial, will learn tomorrow if her application to prevent the media from broadcasting her testimony has been successful. On Monday, the court heard that testifying live could jeopardize her career and safety as a public figure. 5 men are accused of killing the former Bafana Bafana captain during what's believed to have been a botched robbery. This was in 2014. Prosecutor Advocate George Baloyi says that the witness should be allowed to testify off camera and that her concerns are legitimate. But all the defense representatives in the case say that the fears of the witness are baseless. Well, earlier, a lawyer representing some media houses, Dan Rosengarten, said that the witness had failed to produce evidence to support her fears.
My recollection is Mr. Pistorius objected to having his image televised and only wanted his audio, or there was a ruling that only his audio should be broadcast. But in any event, as it transpired, and you'll recall from the matter, the evidence of Mr. Pistorius, including his image, was broadcast. And I repeat the point. We don't know why witness number 1 is scared. There is nothing. Has she been threatened? Has anyone phoned her and said, well, if you say X, Y, and Z, we're out to get you? There's nothing. We've just got a bland statement.
Let's talk further about this then and bring in legal analyst Nthabiseng Dubazana. Nthabiseng, a very good evening to you. Grateful for your time as always. So has there been a strong enough case made by the state and this unidentified witness at this point that indeed appearing on camera or having a testimony broadcast by us in the media would jeopardize her safety and career?
No, actually, when we hear the arguments that have been put forth by Advocate Baloyi on behalf of the state, it doesn't seem that there is sufficient reason that the witness is saying that they cannot proceed with this matter. It seems more or less on the assumption that if this person were to appear, then there could possibly be some repercussions that are going to come as a result. And from what we can gather from the defense attorneys who now have presented their heads of argument, we can gather that this person is already a public figure. It's already known that this person was well known to the deceased and everybody else who is there. And as a result, her fear of, being persecuted or being treated in a different way by society in whole, because she's not specific to say whether or not it's a Nthabiseng who's going to treat her in a certain way, or it is a societal situation where it is in the interest of the public that she do not be shown or be heard when she gives evidence.
And one of the things that the defense teams in opposing this have put on the table is that this figure, this public figure, had already, for example, participated in the recording of other television material related to this trial. So what would be different, for example, in appearing in the Netflix documentary and then having your testimony broadcast on television if the story being told or scrutinized is the same?
If I'm not mistaken, Advocate Baloyi rebutted that statement, stating that when they were responding to the heads of argument of the defense, they said that this witness says that they were not involved in the documentary that was recorded. But that's about as far as it goes. And then, if I'm not mistaken, as well, Advocate Mushalolo was specific to say that there was a post wherein, the advocate for the media houses read out a post wherein about 2,300 people liked that post, wherein she indicates that it's that her day in court is not going to come and the truth should be out there, and yet when the opportunity is here for her to do the same, then she's now reluctant to do so. And then she's also taken a picture in front of the doors of the court and put on social media, which was also liked. So it doesn't make sense. It seems that she's contradicting herself in the reasons that she's putting forth to the court why she should not be televised, and yet on her own private sphere, she's already televising herself with regard to this matter.
How clear, though, Nthabiseng, is law on that when one can consent and withdraw, shall I say, their public identification or public scrutiny, shall we say, of what they say about an ongoing legal matter? Yes, you've made a social media post, and many people would have seen it, even if they didn't like it. In this day and age, it's shared thousands of times across other social media platforms versus saying, well, when I'm in court, I actually don't want that broadcast.
Well, this is why this application needs to be substantiated in such a way that it deals with all these aspects. So the way this application was done, firstly, it was thrown into the face of the state without any real reason as to why this is happening. And then the state bombarded the defense with all of this information. So this was not a very clearly discussed notion between the state and their witness. And then over and above that, the reasons you need to give the court have to be so good, basically, that there is reason to say, all right, let us not give you, let us give you rather the directives that you want, and in order for you to testify in the manner that you want. But right now, there is no reason to do so. In fact, Judge Maumela actually said it seems like the witness seems to contradict herself in what it is that she wants in terms of this proceedings. And then what is worse, or what is even more prominent, not worse rather, is that in the beginning of this matter, pre-trial conference was held. All attorneys came to the fray and they agreed on certain aspects. This should have been one of the things that was discussed, that a witness is not going to want to continue to testify. So when Judge Maumela gives a reading, a decision rather, on whether the media can come in and record the proceedings, it would have included this particular directive. So it's not very well structured by the witness in the state.
Can she be forced to testify, whether, even if she loses, shall we say, this application?
Correct. The court can compel her to come and testify. Remember, she's not there on her own free volition or on her own accord. She was subpoenaed by the court to come and give evidence. So if you make the choice not to come and testify, the court can make an order that should you fail to come and testify, you will be arrested. And then you will be brought from the jailhouse to come into the box and give evidence. And then you will be seen to have been held in contempt of court, because this subpoena is binding you to be in the presence of the courtroom from a certain time to a certain time. And if you choose not to come, you are breaking a court order, which is in itself a criminal charge. So I would advise against not coming into court and saying that, well, my rights are being violated, when you have not shown how these rights have been violated.
Nthabiseng Dubazana, legal analyst, always a pleasure to speak to you. Thank you.